live.
Ladies and gentlemen, welcome to Feddie Night Festivus, brought to you by the Federalist Society Student Division and the University of Tennessee College of Law Student Chapter. My name is Alex Gambino, and I'm the president of the University of Tennessee College of Law Federalist Society Chapter. I'm honored to be here tonight to say a little bit about Feddie Night Festivus and introduce our distinguished guest speaker, Mr. Ilya Shapiro. Feddie Night Festivus is an annual series put on by the Federalist Society Student Division. Over the course of each semester, the Student Division and one law school chapter co-host a virtual showcase event that streams to the Federalist Society chapters nationwide. The University of Tennessee College of Law chapter is delighted to be hosting the final installment of this showcase to close out the 2022 series. Now, a little about Festivus. Festivus was first introduced to the world in 1997 as a secular holiday celebrated by the characters on Seinfeld. Festivus traditionally includes a Festivus dinner and practices such as airing of grievances and feats of strength. Tonight, we are fortunate to celebrate this holiday with Mr. Ilya Shapiro and look forward to his airing of legal grievances and feats of jurisprudential strength. Ilya Shapiro is a senior fellow and director of constitutional studies at the Manhattan Institute. Previously, he was executive director and senior lecturer at the Georgetown Center for the Constitution. And prior to that, he was a vice president of the Cato Institute, director of Cato's Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Ilya Shapiro has authored several books and has contributed to a variety of academic, popular, and professional publications, including the Wall Street Journal, the Harvard Journal of Law and Public Policy, the Washington Post, the Los Angeles Times, USA Today, National Review, and Newsweek. Ilya Shapiro is a graduate of the University of Chicago Law School and also holds degrees from Princeton University and the London School of Economics. After law school, he clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. While in private practice, Ilya Shapiro testified before Congress and state legislatures and has filed more than 400 amicus briefs in the Supreme Court. At the end of this evening's event, we will open up the floor for questions from the audience. You must be logged in as a participant in the Zoom webinar in order to ask a question. Please either use the raise hand function in Zoom to enter the queue or submit written questions via the Q&A function. When we get to your question, you will be called on by name and the Zoom host will unmute your microphone so you can ask your question. If you're calling in from a phone, you can dial *9 on your phone to raise your hand. We are now ready to turn to the main event. Coming to you live from various locations via Zoom, the Federalist Society is proud to present Feddie Night Festivus, Shapiro versus everybody.
All right, well, thanks for that, Alex. And I guess my first grievance is that you read an outdated bio. I've now filed more than 500 Supreme Court briefs, the key being filed, not written. My name is on them, but I have a good team whose excellent work I'm happy to take credit for. So I'm delighted to be here. I'm ready. I hope everyone else is. I have my grievances scroll that I'll be going through. I have my aluminum pole, as is traditional, right here. I have my pen that I'll be taking notes because I'm sure more grievances will come in during this event. I have my Malbec red wine to celebrate the big Argentina World Cup victory. Dale, dale, oh, Argentina. All right, good stuff. And not to forget the Hans Gruber Die Hard Advent Calendar. Look at that. He's almost at the bottom. Fantastic. Well, welcome to FedSoc Festivus, a Festivus for the rest of us. All of us who aren't at the head table at the National Lawyers Convention, all of us whom Leonard Leo does not shower with dark money, all of us with whom Justice Kavanaugh doesn't drink beer. And I tell you, this will be the best FedSoc Festivus ever. Better than Richard Epstein's bizarre Roman law rant. I mean, just because the name of the holiday ends in us doesn't mean it has anything to do with Latin, though I have to give it to Richard for staying on brand. I still recall the description of his Roman law class in the UChicago course catalog, which specified that knowledge of Latin wasn't required, but helpful. I bow down to my old professor's depth of legal knowledge and worldly erudition, but he really didn't understand this assignment. And then, of course, there was Josh Blackman's recitation of Supreme Court history. What a walk down amnesia lane. And what's with all his over-the-shoulder graphics? Did he think he was running some sort of poor man's weekend update? I'm as big a fan of Dennis Miller as the next Gen Xer, but you won't see any of that fancy high-tech mumbo jumbo here. After all, PowerPoint is unconstitutional, at least as applied in 90% of cases. And don't get me started about Josh's hair. I know he's still sore about not getting cast in Weird Al's biopic, but come on, for Festivus, you need more Jerry Seinfeld and less Jerry Curl. See, what you want is this good old aluminum pole with no frills and no fuss. And of course, an ugly Festivus sweater, this one representing the Washington Capitals, who flamed out of the playoffs in the first round yet again, as did, by the way, my other team, the Toronto Maple Leafs. Now, some people, most notably my nominal doppelganger, Ilya, and you can tell us apart, right? He's the smart one, I'm the funny one. So people like the other Ilya say that you're only supposed to cheer for one team, that it's inexcusable sports bigamy to do otherwise. To him, I say, stick to your fantasy world of science fiction. You may be a tenured professor at George Mason, but I'm professor emeritus at Georgetown. You may appear in the Washington Post opinion pages, but I've been on the front page of the sports section with my Caps Leafs Franken jersey. True story. And here I am with my Maple Leafs t-shirt underneath the Caps Festivus sweater. Anyway, it's time for all of you to stand back and stand by, to buckle up and buckle in. And may I suggest pouring yourself an adult beverage. Even more important for you than for me, because the more you drink, the wittier I am, and the easier my grievances will go down. Because look, I've got a lot of problem with you people, and you're going to hear about it. All right, my first grievance, and with apologies to Chief Judge Sri Srinivasan for getting him into this mess, is judicial affirmative action. Now, I don't mean the case now pending before the Supreme Court, where the justices are going to tell Harvard that it's wrong about Asians having bad personalities. That'll be next year when maybe John Yoo hosts Festivus. No, I mean picking judges based on anything but the content of their character and legal acumen. Now, you may recall back in January, Prime Minister Ron Klain leaked that Stephen Breyer was retiring. He had to look in that vacancy, lest Justice Breyer changed his mind while spinning a 3-minute hypothetical. Now, I criticize President Biden's decision to limit the pool of potential Supreme Court candidates by race and sex. I argued that for a Democratic president, Judge Srinivasan was the best choice, meaning that everyone else was less qualified. So if Biden kept his promise, he would pick what, given Twitter's character limit, I inartfully characterized as a lesser Black woman. Now, I could have phrased that better, so I deleted the tweet. But I maintain that Biden should have considered all possible nominees, as 76% of Americans agreed in a poll conducted by that semi-fascist, ultra-mega media outlet, ABC News. Alas, my tweet delete came too late, as my ideological enemies, led by Twitter troll Mark Joseph Stern, willfully misconstrued my words and called for my head. I was suspended from my new position at Georgetown Center for the Constitution, pending investigation into whether my comments violated university policy. And we've since seen how important the Center for the Constitution really is, because the rest of the law school is the center against the Constitution. So anyway, a month later, I wasn't allowed to express my ideas on another campus. Indeed, shut up was the response, cleaned up for this society of ladies and gentlemen, that I got from students at UC Hastings College of Law. They stopped my event from taking place, chanting and banging as if it were Occupy Wall Street. It was actually the first and only time I've ever been protested in more than 1,000 speaking events. I don't know whether I've been doing something wrong or right otherwise. And it's a damning indictment of the state of academia at a time when a toxic cloud has enveloped all our public discourse. So that leads me to my second grievance, the illiberal takeover of law schools. Although the Hastings FedSoc chapter had booked a room and invited me to discuss a topic on which I'd written a book, Supreme Disorder, Judicial Nominations, and the Politics of America's Highest Court, now out in paperback, updated through the Ketanji Brown Jackson confirmation. You can still also get it in CD and Audible and Kindle. In fact, I suggest you get it in all formats just to be safe. But anyway, the book became all the more timely when Justice Breyer announced his retirement. But alas, a heckler's veto prevailed. Applying a bad faith lens to a poorly phrased tweet, activists adjudged me a racist misogynist and my expertise illegitimate. The vocal minority of students who shut down my event wanted to hear neither my reasoning about President Biden's selection criteria nor my broader analysis of the confirmation battle now that there was an actual nominee. And they did so in the vilest language imaginable, which I'm not going to repeat here, several times getting literally in my face or blocking access to the lectern. My erstwhile faculty interlocutor, meanwhile, Professor Rory Little, he's a piece of work, he only encouraged them, saying he was all for it in the video that someone captured. It's great. They hoisted themselves on their own petard by live streaming video of this whole shenanigan. The protesters also castigated their own law school for allowing me to speak, and in a concurrently circulated letter called for, quote, a committee of diverse student representatives, unquote, to approve speakers, among other demands about mandatory training in critical race theory, among other things for students and faculty. Now, never mind that Hastings as a public institution would be violating the First Amendment if it disapproved speakers based on the content of their speech. And never mind that, as one of Hastings' deans advised the protesters in the few minutes when they weren't chanting and banging, not allowing a duly invited speaker to speak went against school rules. As the school's chancellor, David Fagman, pointed out in a community-wide email the next day, quote, disrupting an event to prevent a speaker from being heard is a violation of our policies and norms, which the college will, indeed must, enforce. But it wasn't enforced, and nobody was disciplined, as the chancellor's further equivocating email, 20 deanly pages, detailed a month later. You'd think that law students should have a greater appreciation for spirited and open engagement with provocative ideas than undergraduates. After all, you'll be facing much harder situations in your legal careers than bad tweets. But my experience was no isolated incident, not even for March 2022. The following week, a similar thing happened at Yale, ironically over a panel bringing together lawyers from left and right who agreed on the importance of free speech. Dean Heather Gerken basically buried her head in the sand. But luckily, my friend Jim Ho got her attention, didn't he? Yeah, he's no boring Asian. There you go. Then it happened again at the University of Michigan, when students obstructed a debate on Texas's heartbeat bill, featuring its architect, Jonathan Mitchell. Back in law school, we called him Johnny Mitch, and boy, he really did a number. But you may not have heard about that third disruption at Michigan. It wasn't live streamed for whatever reason. I only knew about it because I was due to speak at Michigan the following week. And the deans brought in all of the student organization heads and told them, we do not want to be Yale or Hastings. So good for them. But the only thing that these events had in common was that non-progressive speakers were presenting ideas that some students found objectionable or offensive. We've gotten to a place where questioning affirmative action or abortion is outside the academic Overton window, the acceptable range of policy views. But this problem isn't limited to ivory towers and leafy quads. The trend of canceling speakers rather than challenging them also represents the loss of grace in our culture more broadly. The desire to ascribe malign motives to one's political enemies, and unwillingness to think of them as merely wrong rather than evil. So that brings up my third grievance, cancel culture. Given the left's control of the commanding heights of culture, education, and technology, those expressing conservative views are much more often targeted by both online and real-world mobs. But it happens to lefties too, like Whoopi Goldberg, who's ignorant about the Holocaust, not anti-Semitic. Even worse, it happens to regular people whose meager donations to politically incorrect causes gets them doxxed, boycotted, fired, or in Canada, frozen out of their bank accounts. This cancel culture is easy to diagnose, but hard to remedy. Too many people have lost sight of the golden rule of treating others as they want to be treated. Although often ascribed to the Bible, that principle predates Christianity and indeed need not be tied to any faith. Still, as American society is secularized, politics has replaced religion to fill the spiritual needs that humans have had since time immemorial. In that context, it's easy to see one's political opponents as heretics. And then, of course, their sacrilege isn't worth hearing. The problem goes far beyond academic freedom or speech on campus, worrying as these developments are for the next generation. It's even more important to have a national reckoning about our inability to discuss controversial issues without canceling those with whom we disagree. How are we to continue as a nation if every policy disagreement is existential and every election a Manichaean battle? Back in February, I jokingly tweeted at Whoopi that she and I ought to go on Joe Rogan's podcast to hash stuff out. I actually found her publicist's contact information and tried to reach her. Haven't heard back. But I'm willing to go anywhere, even The View, to debate constitutional law or the importance of civil discourse. If anyone has any contacts with Bill Maher, that would be awesome. But it'll take more than canceled professors and pundits to get us back to a place where we can disagree without wanting to ruin the lives of people with whom we have those disagreements. It'll take real courage from political leaders and cultural influencers to disrupt the current toxic moment. Now, as for me, after a 4-month investigation into that tweet, Georgetown reinstated me. But after a full consideration of the report I received from the Office of Institutional Diversity, Equity, and Affirmative Action, another Orwellian name, the IDEA, and after consulting with Randy Mardent, my boss, my lawyer, Jesse Banal, other trusted advisors, especially my wife, who's a better lawyer than all of us, I concluded that remaining in my job was untenable. So I did what everyone else does in this situation. I published a resignation letter in the Wall Street Journal. Paul Clement did the same thing the following week. So this is, what one does, and that Paul's thing could set up a grievance with big law for that matter. And then, again, par for the course, I announced my next job on Tucker Carlson's show, and I've now spent, more than 5 months with the Manhattan Institute. You've heard of the Scaramucci, right? Like 13 days, I think he lasted in the Trump administration. Well, I lasted 4 months and 6 days at Georgetown. So that is now the Shapiro. I've lasted longer than a Shapiro at MI. But this brings me to the subject of my 4th formal grievance, Georgetown Dean Bill Traynor. He cleared me on a technicality that I wasn't an employee when I tweeted. Of course, it took paying about $1 million to Wilmer Hale to figure that out. Some junior associate finally looked at a calendar. But it set me up for discipline the next time I transgress progressive orthodoxy. Instead of participating in Traynor's slow motion firing, I resigned. IDEA, remember that office? They speciously found, the diversicrats there found that my tweet required, quote, appropriate corrective measures to address my, quote, objectively offensive comments and to prevent the recurrence of offensive conduct based on race, gender, and sex. Traynor reiterated these concerns in a statement, further noting the, quote, harmful nature of my tweets. They made clear that there's nothing objective about their standard. That people were offended, or at least claimed to have been, is enough for me to have broken the rules, the manufactured outrage on Twitter. It's enough. IDEA asserted that if I, quote, were to make another similar or more serious remark as a Georgetown employee, a hostile environment based on race, gender, and sex likely would be created. All sorts of comments would have subjected me to discipline. Considering the following hypos, which actually aren't all that hypothetical. Let's say I laud the Supreme Court decisions that overruled Roe v. Wade and protected the right to carry arms. I did, in fact, do those things. Now, you can imagine if I were at Georgetown that an activist could have claimed that my comments, quote, deny women's humanity and make her feel unsafe and directly threatened with physical violence. Indeed, this is what happened to Hogan Lovel's partner, Robin Keller, as she detailed in the Wall Street Journal. Next, when the Supreme Court heard the Harvard and UNC affirmative action cases this fall, let's see, I was still in Georgetown and I opined, as I did, that the Constitution bans racial preferences. Well, you could imagine hundreds of Georgetown stakeholders sign a letter borrowing language from Traynor's statements that my comments, quote, are antithetical to the work we do here every day to build inclusion, belonging, and respect for diversity. What's a little Constitution between friends? Or how about this example? Let's say I was at Georgetown this fall teaching a class, Supreme Court amicus strategy or something, and a student is uncomfortable with his assigned position in a mock oral argument in 303 Creative versus Elenis, a case asking whether a designer can be compelled to create a website for a same-sex wedding. Quote, to argue that someone can deny service to members of the LGBTQIA2+ community is to treat our brothers and sisters as second-class citizens, and I will not participate in Shapiro's denigrating charade, he wrote on a listserv. Now, I could go on, but you get the idea. I took these from my resignation letter. Really, this is not, it did not take me any time at all to write that section, these so-called hypotheticals. It's the Georgetown administrators, especially Dean Traynor, who created a hostile work environment for me. Fundamentally, what Traynor did was to repeal the speech and expression policy he claims to hold dear. The freedom to speak is no freedom at all if it makes an exception for speech someone finds offensive or counter to some nebulous conception of equity. And Georgetown showed how it applies even its self-contradicting so-called principles inconsistently. Contrast my case with these examples. 4 years ago, during Justice Kavanaugh's confirmation process, Professor Carol Christine Fair tweeted the following, quote, look at this chorus of entitled white men justifying a serial rapist's arrogated entitlement. All of them deserve miserable deaths, while feminists laugh as they take their last gasps. Bonus, we castrate their corpses and feed them to swine. Yes. Georgetown held this to be protected speech. 2 years ago, law professor Heidi Feldman tweeted that, quote, law professors and law school deans should not support applications from our students to clerk for judges appointed by President Trump. Quote, to work for such a judge indelibly marks a lawyer as lacking in the character and judgment necessary for the practice of law, unquote. Now, these comments could threaten the careers of all conservative and libertarian students, or anyone who clerks for duly confirmed but disfavored judges. Georgetown took no action. In April of this year, months after my tweet, Feldman, the same professor, tweeted, quote, we have only one political party in this country, the Democrats. The other group is a combination of a cult and an insurrection supporting crime syndicate. She went on, quote, the only ethically and politically responsible stance to take toward the Republican Party is to consistently point out that it is no longer a legitimate participant in US constitutional democracy. Now, unlike I was going to be doing, there was a close quote there, unlike I was going to be doing, Feldman teaches first-year law students in mandatory classes, mandatory 1L classes. I was not going to be doing that, and she yet was tweeting this. This pattern of remarks almost certainly created a hostile educational environment for Republican students, which is a protected class under DC civil rights law. The tweets were quietly deleted without apology or disciplinary action. One last example. These are delicious, aren't they? In May, law professor Josh Chaffetz tweeted, quote, the protest at the Supreme Court, not the justices' houses line, would be more persuasive if the court hadn't this week erected fencing to prevent protesters from coming anywhere near it, unquote. He added, quote, when the mob is right, some but not all more aggressive tactics are justified, unquote. Later, he invited folks to snitch tag at Georgetown Law and taunted that the school was, quote, not going to fire me over a tweet you don't like. Now, Chaffetz was right about that last point because it's free speech for thee, but not for me. It's all well and good to adopt strong free speech policies, but it's not enough if university administrators aren't willing to stand up to those who demand censorship. And the problem isn't limited to weaselly administrators. Proliferating DEI, diversity, equity, inclusion offices, enforce an orthodoxy that, ironically, stifles intellectual diversity, undermines equal opportunity, and excludes dissenting voices. Even the dean of a quasi-elite law school bucks these bureaucrats at his peril. What Georgetown subjected me to, what it would have subjected me to if I had stayed, is a heckler's veto that leads to a star chamber, to mix metaphors. Quote, live not by lies, warned Alexander Solzhenitsyn. Let the lie come into the world, let it even triumph, but not through me. I couldn't live that way, so I made what we lawyers call a noisy exit, and I'm using this platform I've been given to shine a light on the rot in academia. So back to grievance 2, the legal academy writ large. When Justice Thomas withdrew from teaching at GW Law School, it was just the latest example of the poisonous atmosphere in academia that makes it impossible to have a free exchange of ideas. GW administrators had admirably stood up to the mob, demanding that he be canceled, Justice Thomas be canceled for his vote to overturn Roe v. Wade, citing academic freedom guidelines. Still, the justice presumably figured it wasn't worth the aggravation. Now, it's a shame that Justice Thomas felt the need to withdraw, in a stark contrast to the announcement that Justice Breyer would be teaching a class at Harvard. That's a shameless double standard. Look, I'm generally long on America. Like Justice Kavanaugh, I live on the sunrise side of the mountain, but I'm pessimistic about academia. Perhaps we've passed peak woke in society writ large, as normal people concerned with their families and livelihoods rather than performative virtue signaling call out progressive fascists. The pandemic showed a lot of parents the faddish theories their kids were being taught in school, and they didn't like it. So I do hope that we've passed peak woke more broadly. I see green shoots. We'll see. But we may have passed the point of no return in terms of the illiberal takeover of higher education. And I do mean illiberal. What we're seeing is not, I want to be quite clear, is not the decades-old complaint about liberal professors. I mean, I still think of myself as fairly young, certainly immature. I was only in law school 20 years ago, college 25 years ago. I don't think the ideological ratio has changed all that much. But now what we have is weak administrators who placate the radical left. So I'm pessimistic that anything will change at any school where academic freedom and free speech aren't supported, where rules against hecklers' vetoes aren't followed. Too few educational officials follow the example of Chicago President Bob Zimmer, who, in response to pressure to punish Professor Dorian Abbott for criticizing certain affirmative action programs, reaffirmed the commitment to faculty members' freedom to, quote, disagree with any policy or approach of the university. Wherever deans and presidents and provosts stand up for free speech and the core truth-seeking mission of any academic institution, the mob disperses. But most university officials don't have the stomach or the cojones for that. The problem isn't that deans like Bill Traynor and Heather Gerken are social justice warriors. They're not. It's that they're spineless cowards who are unwilling to confront the illiberal inmates who've taken over their institutions, including as fellow administrators in burgeoning DEI offices. Pixelated statements about academic freedom and declining to fire Supreme Court justices aren't enough. Schools have to affirmatively instill a culture of respect for opposing views and civil discourse. I'm not holding my breath. And now, instead of continuing with this kvetching, I'm going to let my remaining accumulated grievances reveal themselves as I engage in assorted feats of jurisprudential strength. For example, the term's biggest case, Dobbs, while correct in result, is based on the weak Glucksberg test, which in turn rests on the sandy foundation of Caroline products, which itself came about from the constitutional warping produced by the slaughterhouse cases. And even the compromise, Roberts' typical offered solution in Dobbs, which I've only been able to identify one person who's agreed with that, Ilya, as it happens. That didn't satisfy anyone either, even less principled. And don't get me started about how our continued pen and phone governance led to COVID-related constitutional abuses that in turn can be blamed on Wickard versus Filburn and Gonzalez versus Raich. From wheat to weed, I challenge anyone to pin me on that score.
All right, we'll go to our first question. Devin Watkins.
Devin, my former associate, are you speechless?
I guess so. I'll read his question for you.
Devin
Devin
says, he didn't want to appear on the screen. He probably did not take to heart the lessons I gave him in using collar stays to make your collar lie flat, making sure your tie is always tied up there. Fine lawyer, but some of the sartorial choices, I don't know.
Devin says, do you think courts in the future will start to force more academics to respect the First Amendment, including penalties under Section 1983?
That's interesting. I think there might be greater success if we're talking about litigation over such things, enforcing actual contracts, because these schools like Georgetown is a private school. There are lots of private schools, obviously. They're not bound by the First Amendment, but they have these wonderful sounding policies on paper and pixels, as I alluded to. And certainly those could be breach of contract and other claims. And I can't go more into that because the statute of limitations on my own potential claims hasn't run yet. But in the public sphere, I think it is possible that there could be certain things. And as other legislation comes down the pike, now I wouldn't want legislators to start legislating about what professors say in class, but I would like some targeting of these worse than useless bureaucracies that have arisen. Come on, anyone? Are we done already? Have I out-grievanced everyone?
Ilya, this is Andrew Grossman.
Hey, Andrew, talk about sartorial choices. Now you got to put yourself up on the screen because I'm sure you're wearing like some sort of very tailored latest, not even fall 22. You're probably wearing the latest from what Milan is about to show from spring 23.
My bathrobe is quite fetching. For a lawyer, as you know, the true test of strength is being able to argue both sides of a case. And the case for this feat of you is Barr versus American Association of Political Consultants. You know the case. The Telephone Consumer Protection Act generally prohibits robocalls to cell phones and home phones. A group of political and nonprofit organizations challenged the prohibition as an unconstitutional content-based restriction because a government debt exception to the prohibition favored debt collection speech over political speech and other speech. And the court agreed, but its remedy was to strike down the exception. In other words, to punish third parties using robocallers for debt collection. The organizations who brought the suit, they got nothing. I don't know, maybe their lawyers got a quill or something. So here is your feat of strength. If the only available remedy is punishing unrelated third parties, how on earth did the organizations have standing to bring suit? I mean, I read Justice Kavanaugh's opinion. Frankly, it read like a Chief Justice opinion. It made sense at the time, but I couldn't tell you why they had standing if you put a gun to my head. That is a question that only can be answered by a strong man. So are you up to it, Mr. Shapiro?
Well, that kind of question is like, don't throw me in the briar patch sort of question. Briar, B-R-I-A-R, not the long-winded hypothetical briar. I filed a brief in that case on the, as it were, winning side, which was a Pyrrhic victory, as you alluded. Now, I did not take the remedies course that was offered at my law school. I think Richard Epstein probably taught it. Well, he's taught everything in the law school course catalog, so I'm sure he taught it at some point. Not sure whether he taught it while I was there. So that one left me head scratching. You're right. I hadn't thought about the two sides of the same coin with standing and remedy being on opposite sides. But you're right. If there was, if the winning side correctly identified a constitutional defect, I don't think the result is to make that constitutional defect apply equally to everyone. That's just not right. It would have been, I think, fairer and more principled to say, no, there is no constitutional defect here and let things stand. But yeah, I'm afraid that it's not a pin because you've challenged me to, I don't know, do the undoable, if you will, but I can't make a case for Justice Kavanaugh's remedy opinion there, other than to say they simply didn't want to go whole hog and strike down the entire restriction for everyone.
Christopher Green, go ahead.
Chris Green, no doubt calling in from his flip phone.
No. I've got I have my laptop. We drove up from Oxford to Chicago, went through several different circuits to get here. So I had a sartorial question, which is, you're working for this institution named after Manhattan. But don't they at least require you to have a New York area hockey jersey as part of your outfit?
God forbid, that would be a festival nightmare. No, not absolutely. In fact, I like to say that I'm heading up the very elite Falls Church, Virginia office of the Manhattan Institute. It's funny. I was in New York more before I joined MI. I think I've been there once since joining them. And luckily, I would have stricken that if that had been in my employment contract. That would have been what do you call it? Not ultra vires, but the unconscionable. That would have been unconscionable. And so absolutely not. I do sports bigamy, but I draw the line at cheering for New York teams.
So yeah, that's very different from Josh Blackman, he's one of these people who is rooting for the Yankees all the time, which I think is terrible. But my more serious comment, I mean, it seems to me that you've got to think, we all need to think more seriously about the 14th Amendment, at least for these public law schools like Tennessee. The preamble to the Civil Rights Act of 1875 talks about equal citizenship for people of whatever nativity, race, color, or persuasion, religious or political. And the whole notion that, one kind of equality matters, but equality for all citizens of all religious and political persuasions, well, that part just doesn't matter. I mean, it's just not the principle of the 14th Amendment.
Are you arguing that political persuasion or affiliation or ideology is already a protected class, that like Seattle and Berkeley and DC didn't have to add it to their civil rights codes?
Well, as a matter of 14th Amendment history, obviously we'd have to fix a lot of stuff about the tiers of scrutiny and everything. But as a matter of
I'll add it to the
history,
list.
yeah.
Fascinating.
So I just wanted to ring that bell. So.
Got Jesse, would you like to ask your question?
Jesse, who's a wonderful lawyer, got me reinstated, but I haven't seen the $1 million check from Georgetown. Maybe get on that right after this Zoom, Jesse.
I'll call him and I'll see if it got lost in the mail. I have a feeling it didn't, however. But that's a great.
I'm having a hard enough time getting $100 bucks back from Georgetown that I deposited to like pay for parking on one of those, the Go card thing that they have. Finally, I told my credit card company to like stop payment, that was a dubious, fraudulent thing, and so far that's been working. So that which makes sense. Georgetown as a whole is just a fraudulent, dubious institution. Anyway,
maybe you should talk to the DOJ. I hear they have nothing to do these days in the Washington, D.C. area. So some credit card fraud might be up their alley. But, I'll say, first of all, happy Festivus, Ilya. And, I actually went and got a cameo from a celebrity. But let's just say that Justice Jackson didn't exactly pronounce Season's greetings right. So that didn't work out. I'm sure that Judge Srinivasan would have gotten it exactly right, however.
At least I can help Justice Jackson. I think it's Merriam-Webster updated their definition of woman, and so she can just I don't know whether they're biologists or not, but at least we do have a up-to-date dictionary definition, so she can rest easy there.
Yes, excellent. Well, and I'm sure she will appreciate that in her somewhat long-winded questions that she's asking from the bench on such topics. But yeah, my question is, and because I like to stir it up with the Federalist Society here a little bit, is I hear from some of the things that you've said, and maybe from a little bit of my own experiences, that with other clients, that private institutions like universities are not exactly being fair and open when it comes to discrimination themselves. If a lot of this was coming from public universities, there would be a very clear Section 1983 lawsuit when there's railroading through these organizations like IDEAA and others. Why exactly is it that so many people in our organization and others like us are so hung up on holding these private institutions to account, especially when they're taking tax dollars both from the federal government and from state governments.
Well, I mean, this relates back to the affirmative action case, right? At least under Title VI, educational institutions that get federal funding are subject to the exact same rules, constitutional standards, and otherwise that that public institutions are. And so perhaps if you know, certainly if you're taking federal strings, then we should look at the Department of Education and otherwise should look at whether these institutions are you know, violating the First Amendment in addition to violating the 14th Amendment. And I thought where you were going with this was perhaps to treat private institutions the same as public with direct application through federal funds. I mean, that could well be the next claim. So I'll look for a draft of the updated draft of my complaint against Georgetown in my inbox. You know, you sleep in. Let's have it by 9 a.m. tomorrow, let's say.
Yeah, it might be 9:35, but you know, you look at it and give me a call once.
I'll be up. I have twins at home, so I have no idea what day it is, what time it is. This is the other thing about being with MI these days. I work from home for a think tank and I'm on paternity leave to boot, so it is just a complete mess around here.
Well, good luck getting some sleep eventually, and happy Festivus.
Next up, Andrew Grossman.
Back for more punishment.
It is me again, but I don't speak on my own behalf. I speak on behalf of our friend Trevor Burrus, who this evening has unfortunately overindulged in NyQuil.
I
Trevor
commend to everyone Dennis Leary's epic rant about NyQuil, by the way. Speaking of Dennis Miller asides for all you Gen X listeners, that all the students listening are like, oh, there you go. You know, okay, boomer. No, it's not boomer. There's a generation between y'all and the boomers. So anyway, I digress.
Trevor proposes to you a feat of strength. As you recall, as you know, Mrs. Bell is one of the Supreme Court's most appalling decisions.
What is
all the Buck versus Bell?
Yes.
And it is made all the worse by Justice Holmes's disgusting rhetorical flourishes. Your feat of strength, however.
How many generations of imbeciles is enough for you, Andrew?
You know, I cut the limit at 1, but, you know, we vary on these things. But your feat of strength is not about the decision, but what led up to it. What did Carrie Buck's attorney neglect that even an imbecile would have done? Seems like you need a drink for that one.
What did he neglect? Well, I know that there was some question about whether Carrie Buck was actually, as they put it in the language of the time, feeble-minded. I don't know whether he objected to that as opposed to the underlying rule.
You know, Trevor informs me that even an imbecile would have filed a brief.
Yes, that's something that we try to teach our associates. Definitely best practice. There's your CLE. Some people ask whether they'd be getting CLE for this Festivus. And I thought, hey, I'll sign whatever you want me to sign to try to get credit. But there's one CLE practice tip. Definitely file a brief.
What we tell all of our associates.
Didn't something like that happen in the last Second Amendment Supreme Court case before Heller? Miller from 1939, I think, didn't file a brief. There was something along those lines.
That's right. That happened in Miller. It effectively also happened in Hilton. That is the carriage tax case. You have all of these seminal
legal practice used to be so much different. You don't file a brief. You just show up to argue for days and days at the court. I don't know. Well, maybe Andrew, one of these days you'll get to argue if Ted Frank doesn't steal any more cases from you.
That is a separate grievance.
I think we have a challenge from Adam. Go ahead, Adam.
Ilya, I have a grievance.
This is Ilya Shapiro, not Soman. So if this is Star Wars or Star Trek or whatever, Battlestar Galactica, all of those, that's not me. I do sports, not sci-fi. I was the jock in a nerd school, so I'm not into all of those, writing about the libertarian theory of Star Wars and whatever. That's not me.
Yes, Ilya, you have been a constant disappointment to the other Ilya and me for many decades as a result of this lack of faith on your part. But I want to go back to your talk today and your unfortunate bait and switch. I thought when you showed the awesome Hans Gruber advent calendar that instead of talking about the massive institutional failures and breakdowns in our society, you are going to talk about the fact that we can never tolerate anyone who actually believes that Die Hard is not a Christmas movie. It is not Christmas until Hans Gruber falls from Nakatomi Plaza. And so I put to you, would you be willing to at least go that far and to at least admit that we cannot tolerate people who will not recognize this? Please,
Well,
Ilya,
I think
Booby,
that even
be our
under,
white knight.
even under Chris Green's inventive theory that I just heard today for the first time, that political affiliation is already protected by the 14th Amendment, I don't think characterization of movies in their relationship to holidays is a protected class. So maybe we ought to have some legislation adding that point, because I do believe that because the movie takes place at Christmas, there's language about ho, 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 and all. It clearly qualifies as a Christmas movie. I don't know whether we need to add a protected class, but I think it's definitely, if an associate came to me and started arguing, or a clerk or whatever, that it wasn't, that would definitely, I would think less of that person's judgment, and the law should support any adverse employment action I took based on that understanding.
Well, don't forget to place a Twinkie, a pack of cigarettes, and a firearm in the ductwork of your house on Christmas Eve for John McClane.
My house dates to 1860, so I'm sure there's all sorts of stuff in the ductwork. Although we do have ductwork, it does now have indoor plumbing and electricity and all those modern accoutrements.
We'll go to Brandon. I think Brandon has a question in the chat. I'll read it off for Brandon. He asked, can you explain more about what problems you have with the Dobbs decision? You mentioned some problems with Robert's opinion, but can you explain more of what you were talking about with the constitutional history that led to the decision?
Sure. So my problem is with the modern unenumerated rights regime, right? Where do we look when we analyze cases under existing jurisprudence about whether an asserted rights claim that's not based on an explicitly protected right in the Bill of Rights? How do we look at that? Well, the governing test is Glucksberg, whether something is, when you define it properly, which is, kind of the whole ball game there, whether you define something narrowly or broadly, but you define it precisely, and then whether it's whether it's deeply rooted in the nation's history and tradition and part of ordered liberty. That test is invented out of whole cloth. I mean, it's not a bad test if you were inventing law out of whole cloth. And of course, to do something different, the court in Dobbs would have had to overturn or at least change Glucksberg as well. And they didn't want to do that, given that they were already overturning Roe. But as an originalist matter, you would, first of all, this would be a case under privileges or immunities, which, as I said, Slaughterhouse eviscerated. And so we went into this constitutional malapropism of incorporating rights against the Constitution, et cetera. And unenumerated rights is whatever you can get 5 votes for. So all of that history of if you're doing it right, if you're being purely originalist, you would go to the Privileges and Immunities Clause, look over the debates of the ratification of that, which brings in Corfield versus Coriel and Justice Bushrod Washington writing circuit and all of these other things for evidence of the sorts of natural and civic rights protected by the Privileges or Immunities. We could bring Chris Green on here to, you know, spend 24 hours. He barely scratched the surface of the first comma placement of all of this. But anyway, that's the issue there. It's not that it was wrong on its own terms. The application of Glucksberg, I think, was perfectly fine and accurate. But you know, it wasn't the ideal way of interpreting an unenumerated rights claim.
Let's go to Gideon now.
Hi, can you hear me?
Gideon, my favorite, my fellow Canadian American, you know, like most immigrants, you know, we do a job that most native-born Americans won't, defending the Constitution. So
exactly,
it's like that. It's like that last movie by the late great Canadian American actor John Candy, right? The public service announcement: Canadians, they walk among us. So we blend in and all that. All right. Happy Festivus. What's your question?
Thank you. Happy Festivus to you as well. I was curious about, first of all, stories of, or what you heard of people doing either to celebrate the Dobbs and Bruin release, either or both. Maybe some people were happy with one but upset at the other, so it negated. That was not the case for me. I was also enticed to discuss the Glucksberg case with you and unenumerated rights on the legal side rather than the experiential side of the law. I would ask how you figure the Ninth Amendment plays into this discussion at all. It's been a while since I did Glucksberg, but I would have to say that something to do with the Ninth Amendment should come into play when you're talking about trying to interpret the more implied or softer or kind of the outer bounds of, dare I say, penumbras of some rights that actually do exist.
So first, I'll commend, before I forget, an article that Josh Blackman and I co-authored 12 years ago during the almost 13 years ago during the pendency of McDonald versus Chicago, called "Keeping Pandora's Box Sealed," and it's all about the 14th Amendment and why penumbras is wrong and incorporation is a constitutional malapropism and all of that. So do I have any experiences with people celebrating Dobbs and Bruin? Not really, because when those cases came down, I was in Sicily. Now, I was not at the White Lotus. I was at a Club Med, which was excellent. I recommend it. I was there for my 45th birthday, and the number 45 is iconic for the Club Med brand. This is kind of a funny story, if you'll indulge me about this. So my family, we're big Club Med fans, especially if you have kids. They take your kids off your hands like 9 to 5 every day. You can have a proper vacation. It's also very active. You get to play, you know, tennis and kayaking and bocce and all the different stuff. It's great. But anyway, for their 45th anniversary in the 90s, they put out all this marketing campaign and this swag and these t-shirts with the number 45. And it was a very successful marketing campaign. So 5 years later, for their 50th, you think 50, that's half century, a bigger deal. They like went all in on that, and that was a flop. So they reverted to 45 as being part of their brand. I found that awesome. So I thought, for my 45th birthday, I have to be at a Club Med. So there I was in Sicily for the first time in forever, being out of the country, not constantly at my laptop during hand downs and, you know, let alone at the marble steps giving commentary, which I've done in the past. You know, I looked at the decision. I skimmed, you know, certain things, SCOTUS blog, chat, whatever. Fired off a press statement or something like that, gave it to some, and then went to dinner with my family, and it was excellent. I broke my rule of not doing any work or media even during that 2-week vacation only twice. One to do a requested op-ed, and once to do, I think, no, it was a Fox News hit and a what was it? The Hugh Hewitt show, I think it was, on the radio. And I did both of those. One of them was poolside, one of them was outside happy hour at the thing, but I digress. So I have no idea how people were treating either of those decisions. I was having a Negroni and looking at the waves roll in.
We will go next to Jim. Before we go to Jim, just last call for any grievances or challenges.
No, this is not last call. I'm here until I'm pinned, and I won't be pinned. If there's interest, I will take questions. And FedSoc said there was no hard stop. So I'm, my kids are in bed. I've got my wine. I might need a refill, but anyway, I think I'm here for the duration until all of you are pinned. In fact, Jim, my colleague.
Yes, well, I am your colleague, and therefore I have lots of grievances. But I want to challenge you to a feat of strength based on your initial grievance, the raison d'etre of your difficulties with Georgetown. This being
their difficulties with me.
Oh, well, they date back to Yale Law School. No, that's the other Ilya. Anyway, we have, I have to question this notion that you have that we should just be looking at judicial excellence and Supreme Court confirmation, the confirmation process. And of course, you're a student of that confirmation process, and everyone likes to talk back to Robert Bork and start things there. Supreme disorder, buy your copy now. But of course, there was an earlier
excellent Festivus gift, let alone Hanukkah and Christmas. And
there was an earlier fight involving the great Republican President Richard Nixon and two of my fellow Southerners who he nominated to the court, the second of whom, of course, was the distinguished long-term federal judge G. Harold Carswell. And you have firmly placed yourself in the camp of the dean of the Yale Law School at the time, Lewis Pollock, and that far from centrist senator from South Dakota, George McGovern, who objected to Carswell on the grounds of judicial mediocrity. And I wonder why you can't simply accept the argument of the great Republican senator from Nebraska, Roman Ruska, who argued that even if he were mediocre, there are a lot of mediocre judges and people and lawyers, and they are entitled to a little representation, aren't they? And a little chance.
yes, I see that you've been reading pages 100 to 102 of Supreme Disorder, where I go into that whole episode. But let me thread this needle by neither agreeing with the dean of Yale Law School nor any reputable law school, nor the senator from Nebraska, because on the one hand, you had someone objecting to Nixon's strict construction strategy. This was why I put 1968 as the pivot point in our modern judicial wars. Judicial philosophy became a thing. Nixon campaigned against the Warren Court for strict constructionism, which was like the proto-originalism, a novel sort of thing. And Nixon picked a judge he thought would be solid for what he wanted. So you don't just pick whoever would score highest on a legal test. That would be Sri Srinivasan, perhaps, regardless of whether you're a Republican or a Democrat. But ideology and jurisprudential theory does play into it. But regardless, within your parameters of your theory, Ruska, on the other hand, raised a representational point. Right? He said mediocre lawyers need representation. I don't care about that. Find the best person who is, and in those days, it was for Nixon, it was slim pickings. He talked about, he would have loved to have appointed a woman for that matter, because it's good politics, but he couldn't find one that would be that I guess that suited his jurisprudential mean. And I won't go into his own, psychologically assessing, is going to Duke rather than Harvard and Yale and all of these other things, feeling inferior to the Northeastern elite, but that goes into it. So anyway, neither elitist nor identity politics is my mantra.
Of course, Judge Carswell himself was an alumnus of Duke, which I would argue is in and of itself sufficient reason to reject his nomination.
Jim is a UNC alum, so what happens on Tobacco Road stays on Tobacco Road.
We have two questions in the chat. Devin Watkins, would you like to ask yours?
Hello, can you hear me? Okay, so I wanted
Devin
to,
authored a fantastic brief that I was delighted to join in the Loper Bright case, the fishing, right? The not only under this bizarre Department of Commerce, NOAA, National Oceanic Atmospheric Administration, not only do fishermen have to host a government monitor to make sure they're not violating regulations, but they have to pay for the privilege. You might recall that plot point in the Oscar-winning Coda movie. Anyway, this is now up on cert, Paul Clement cert petition, and Devin and the Competitive Enterprise Institute, where I interned nearly 25 years ago. I was happy with MI to go in with him, so I commend that brief to you. But anyway, Devin, I take it that you are trawling down another stream here.
yes, I wanted to challenge you on collusive litigation. Government goes out, finds someone to challenge themselves on a legal issue, and where the government doesn't defend the law at all. They just appeal it and try to get binding precedent on the issue at the highest level they can, with no one defending what the statute says, because no one else has standing, and the court isn't going to allow anyone else to kind of come in and defend the law. And so these kind of collusive litigation.
Yeah, look, courts have to do their due diligence, and it's a judgment call to ensure our adversarial system. Our system of law does not work, our system of jurisprudence, if one side is just phoning it in, as it were. And that's why, we can debate separately the standards on which a Justice Department, whether state or federal, makes a decision not to defend a particular statute or executive action, I suppose. That's a separate decision, but I think they shouldn't be forced to defend something that let alone get away with half-heartedly, throwing in the towel, indeed, to get by a consent decree what they can't get otherwise jurisprudentially or through the legislature.
Ilya, we have a question from Ed about cancel culture. Go ahead, Ed.
Can you hear me?
Yeah.
Okay, great. So when this whole Georgetown thing happened, I don't know if you saw it, Mr. Shapiro, but there was an open letter and a lot of open letter opposing.
Oh, I saw it. I was
Georgetown.
taking notes.
Yeah. And that was from, it included faculty from law schools, and I think even beyond law schools, graduate schools and such. So it seems to me clearly there are people in academia that see that this is a problem. The question I want to ask is, do you think that this cancel culture is a market failure? And if so, what do you imagine the market solution being? Is it going to be that prospective law students just end up going to a place like Chicago or other law schools that have very solid freedom of expression policies and actually enforce them? Or do you imagine something else?
Well, it's a complicated issue because it's not just one variable. There's a market distortion from federal student loan policy and federal funding more broadly. There's a sort of prestige collusion, if you will. That's the first time I've coined that phrase in terms of these so-called T14 schools. Now, I'd never heard of T14 because I didn't feel the need to look past the single digits of the rankings. That's why I ended up at Chicago. But I think there's a real problem, real crisis in academia and also, and perhaps most worryingly, in legal academia and at law schools, because those are training the next generation of public officials and lawyers and all the rest of it. At the end of the day, there's a problem with people going into debt, 300 grand to get a blank studies, undergraduate degree. But what's the perversions of the sociology department are less important to our society than the perversions of leading law schools. So hopefully there's both legislative solutions, there's market solutions. The University of Austin has, people are raising an eyebrow, and potentially there's more room for those sorts of challenges. But indeed, if law schools, I hope there's heterodox pressures. I mentioned Judge Ho's boycott of hiring clerks from Yale going forward, not for current students or alumni. I hope there are other kinds of exogenous shocks on this system because I'm very pessimistic about reform from within, given things are faculty run and now bureaucracy run, and we may have passed the point of no return. Particularly, there's one place where the ideological thing is a little different, even if you look at just bare Republican, Democrat, liberal, conservative, those kind of ratios haven't really shifted in decades. But the younger generations of academics seem less tolerant and more activist, and the millennial academics are more illiberal than the boomer academics, even though they vote Democratic at the same extent. So there are some generational developments in that regard. But in any event, I do hope that exogenous shocks happen. And as George Mason does now in terms of Scalia law, in terms of hiring faculty that really should be at higher ranked or what's considered to be more prestigious places, but there's of course that ideological penalty. I think that's going to increasingly start happening with students. I think it already has at the margins. Why go to Yale when you can go to Harvard, which is clearly still bad, but clearly better than Yale on all these things that we've been talking about, in large part due to Elena Kagan. Actually, she was a fantastic dean at Harvard on issues ranging from intellectual diversity to student life. But that's getting ahead of ourselves here. So I'm vigilant about what's going on at Chicago. I certainly am heartened that it's one of the very few top 14 or 20 or 25 or wherever they break that down, schools not to withdraw from U.S. News things, not because I think U.S. News rankings are particularly useful, but because clearly this is just a preemptive way of trying to have massive resistance to the coming Supreme Court ruling, throwing out being racist in your admissions policies.
I think we have a follow-up from Gideon.
Yeah, I have a question exactly about this. Leading up to some of the things you mentioned, isn't this kind of like the end of an era? That generation of professors that studied, let's say, under the old school liberals and conservatives of the 1960s and 70s are kind of retiring or almost all gone. The U.S. News is gone as well. The LSAT seems to be on the way out too. What will, aside from the alumni networks that's been built over decades, what will sustain the top schools in their top spots without an LSAT, without really being able to evaluate anything like, GPAs vary by rigor of program rather than the actual quality of an applicant. So with no objective standards left, presumably them being destroyed in order to prop up the DEI policies that might become illegal depending on how SCOTUS rules. I think it will rule to make these policies a civil rights violation. What will sustain the extreme prestige that some institutions have held over centuries, being able to project into the real world, into firms, into
look, it's that legacy prestige, and what kind of competitors there are. If everyone's being equally bad, then nothing's going to change. I think schools gain different reputations over time, and I'm heartened to learn, at least anecdotally, that Georgetown has taken a hit from the episode with me, as has Traynor in his personal reputation. That hit is well deserved. I hope that we'll see what happens, and this is one of these Rumsfeldian unknown unknowns, because even though we think, well, this ranking, the top 5, 10, 15, whatever, they move around little bits and pieces here or there, but nothing really changes. That could change in the future. University of Chicago undergrad, from the time when I was applying to college till now, has really changed significantly. I haven't looked at exactly why that is, but I think it's possible. So we'll see. I think there's going to be a demand, certainly, for rigor and actually good education rather than emoting and, whatever it is they teach at Yale, and instead of law. I understand my colleague Jim, while he was there, spent most of his time skeet shooting or something, which is admirable, better than probably what most of his classmates were doing, but still not a reason that one should go to Yale.
What about becoming professional schools, or more like trade schools? Or wouldn't a student that wants to be a Supreme Court advocate be better off doing 2 or 3 years basically as your clerk, as opposed to sitting in a place where they're constantly
Well, the thing
hammered?
is that the practice of law is being disrupted as well, with big law being completely intolerant of anyone who deviates from certain orthodoxy. There are these boutiques that arise that simply were not a thing when I was coming up. I lasted all of 3 years in big law. It wasn't my thing, for various reasons. But I think there's going to be more other kinds of opportunities, and the legal market will respond to, people who are, after all, smart and can write and go to good judges and things like that, and yet they're blackballed. It's a complicated ecosystem, this legal practice. I advise it's too late for all y'all who are already in law school or lawyers and whatnot, but I tell young students not to go to law school. It's kind of like converting to Judaism. You say just no, don't do it. And then if you're so persistent enough, eventually maybe we'll talk about it. But I think we're in for a disruption, because who was it that said that something that's unsustainable will stop, something that can't keep going the way it is will not. Again, I don't know whether we've reached the absolute bottom on these various dimensions that we've been discussing, but living on the sunrise side of the mountain, I have to hold out hope, and certainly, my kids the oldest is about to turn 7 in a couple of weeks, so hopefully all this will be figured out in the next decade.
Well, Ilya, I don't think anyone has pinned you yet. Do you have any other final grievances or comments?
I don't think so. This has been delightful, and Festivus for the rest of us, and all of that. I was sincere in saying that I'm willing to come talk about these and other issues in which I can feign expertise in different places. I love talking to students. This is why I thought about making the change from nearly 15 years at Cato and coming to Georgetown. I believe the children are the future, so happy to travel places and talk in person with both at the University of Tennessee and at all the other fine and even not so fine institutions. Sometimes you have to go off campus to spread the gospel of liberty and originalism and man's last best hope on earth that the Constitution represents.
Well, on behalf of the Federalist Society and the University of Tennessee, we thank you. Thought it was a great Festivus.